Good afternoon and welcome to the New Civil Liberties Alliance. Today's Lunch and Law program is entitled SCOTUS Overturns ATF's Bump Stock Ban. And here to discuss that are two experienced litigators. Our former colleague Rich Samp, who's a seasoned constitutional appellate litigator and current member of NCLA's Board of Advisors, and John Ohlendorf, former law clerk to Judge Ray Grunder of the U.S. Court of Appeals for the Eighth Circuit, a partner at Cooper & Kirk, and the author of one of the amicus briefs in the Garland v. Cargill case. And John is also a former law fellow at Northwestern and Georgetown. Delighted to have you both with us to talk about this case. So, Rich, you were at counsel table and you won this case en banc, arguing at the Fifth Circuit. Maybe my first question for you is: were you surprised with the outcome at the Supreme Court, or was there anything that you didn't expect?
Based particularly on the oral argument, it came out exactly as I expected. It was a 6-3 decision. The 6 more conservative justices all voted to affirm and to strike down the regulation at issue. The 3 liberals all said, well, maybe sometimes we're textualists, but not in this case, because we consider that common sense should overrule textualism, is basically the way they put it.
Right. So we're not all textualists now, apparently.
That's right.
Despite Justice Kagan's admonition in another time. How about you, John? Was there anything in the decision that surprised you?
I thought the substance of the decision was very unsurprising and really proceeded exactly as how I would have laid it out, and how the parties had kind of briefed it. I guess I was not surprised, but interested that the chief was in the majority. I think he was the only one after the argument who I wasn't entirely sure where he was, and just as a matter of first principles, wasn't as confident about. So I think it's interesting to compare the decision in this case with his decision several years ago in the King versus Burwell case, which to my mind kind of represented the triumph of kind of a different conceptualization of textualism that kind of Justice Kagan has championed, and the fact that he went with a much more kind of solid, literal, traditional version of textualism here was not surprising, but encouraging, I guess.
Yeah, that's a good word for it. So, Rich, Justice Thomas wrote the decision for the majority here. What was the holding? What did he say for those who weren't following it closely?
Well, this was really a statutory interpretation case. The Second Amendment was not at issue. The question is whether bump stocks are machine guns as defined by federal law. For many years, the Department of Alcohol, Tobacco, Firearms, and Explosives had said these were not machine guns, and then in 2018, it just shifted gears and said, oh, never mind, we think they are. And the Supreme Court said, no, they're not. And they said so for 2 reasons. First of all, they said that the statute requires that a weapon be capable of shooting multiple shots by a single function of the trigger. And pretty clearly, a bump stock does not allow more than a single shot by a single function of the trigger. And secondly, in the alternative, that the gun has to do so automatically in order to qualify as a machine gun. And what Justice Thomas said, something doesn't happen automatically if it is required that even after pulling the trigger, the shooter has to push forward with his non-shooting hand on the barrel of the weapon and at the same time pull back with his shooting hand. That doesn't sound like automatically to me, and it didn't sound like automatically to Justice Thomas either.
Yeah, and I'd like to give some credit to Judge Henderson on the D.C. Circuit, because I think she was the very first judge to look at this who said, wait a minute, this is not automatic, this is and then some. You have to hold the trigger and then do some additional things. And that and then some language made it into Justice Thomas's decision. And Judge Henderson was looking at this, if I remember correctly, like less than a week after the rule went into effect. So I mean, there was a very short turnaround that she had to look at this, and the reasoning that she applied back in 2019 is essentially the reasoning that won the day 5 years later at the Supreme Court. So So kudos to Judge Henderson. Too bad it took 5 years to get there, and not just 5 years, but $100 million of lost property, 520,000 people who were legal owners of this device lost the device. John, in dissent, Justice Sotomayor said, when I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock equipped semi-automatic rifle fires automatically more than one shot without manual reloading by a single function of the trigger. She quotes the statutory language there. Because I, like Congress, call that a machine gun, I respectfully dissent. So she says it is a machine gun.
Yeah, so she's advocating for duxtualism, if you will, instead of textualism, I think. I think what's striking is if the statute had used a phrase in kind of ordinary parlance, like each pull of the trigger, I don't know that that's the end of the case, but that's certainly a very different case, and there would be much more appeal to the idea of, well, everybody knows what it means to pull a trigger. But the phrase that Congress used it's obviously a term of art, and it's kind of an unusual phrase, right? Function of the trigger, which just as a matter of grammar and syntax force you to look at how the trigger itself is internally operating in a way that is just totally different from this, looks like a duck, quacks like a duck kind of analogy. I think there just is no ordinary, standard, everyday meaning of the phrase "function of the trigger." That's a technical phrase, and you have to determine the meaning of that. And based on grammar, I think obviously the meaning is the one that Justice Thomas and the majority rove at.
Rich, one of the things that the dissent did was sort of mock is too strong, but maybe poke fun at the fact that the majority had so many diagrams in it. And the implication seemed to be, well, if you're using that many diagrams, then obviously you're trying to come up with a loophole or something like that. I mean, I found the diagrams helpful. I mean, maybe not at this stage of the case because I was already familiar with it, but anybody coming new to this subject, I mean, I think the diagrams are extremely helpful. What did you take of that sort of back and forth between, somebody said this is the most diagrams they've ever seen in an opinion that wasn't a patent opinion. So what did you think of the use of the diagrams and whether that sort of critique was valid or not?
Well, I did find the diagrams helpful for people understanding the opinion. And I think it just simply accentuates the difference between textualists and non-textualists, that the diagrams help to explain why the text of the statute required the decision that they reached. And if you object to all of these diagrams, what you're really saying is, who cares about diagrams? What really counts is what was the purpose. And I have no difficulty discerning that what really was in the minds of 1934 legislators was we ought to get rid of dangerous weapons, and we ought to therefore leave it up to the federal bureaucrats to decide what is too dangerous to allow on the market.
Right, and yet those legislators didn't ban Gatling guns. There's lots of other rapid fire kinds of devices that weren't covered by the ban, and yet that didn't seem to phase the dissent.
Well, that's true, but what the dissent would say is, but the experts are the ones who should be deciding this. They're the ones who should decide what's too dangerous, and they've decided, for whatever reason, that Gatling guns aren't too dangerous. Then we should allow them, but don't allow the courts to step in the way of what the administrative state decides the law should mean.
What about this expertise point, John? I guess I'm not totally convinced that the ATF experts were the ones making the call here.
I think that's right, and given the what we know about kind of the history of their decision, I think undermines the idea that it was a matter of expertise. But there's kind of a tension there, right, between the idea that this was, some specialized exercise of the ATF's expertise on the one hand, and then on the other hand, well, it's just ordinary meaning, and everyone knows this is a machine gun, right? And I think the diagrams go to this idea that this is a technical phrase in a statute that you have to understand in terms of the technical functionality of firearms. And you wouldn't, in, say, a tax statute dealing with complicated financial transactions, you wouldn't say, well, I know what profit means as a matter of ordinary meaning. I don't need your silly diagrams and spreadsheets to tell me if there was a profit here. No, you would recognize this is a technical area, and you have to get down into the details to see whether or not the conduct at issue here meets the technical terms of the classification that Congress drew.
Yeah, I think one of the virtues of the decision from my vantage point is certainly everybody who is familiar with firearms understands what is and isn't covered by this terminology now. And Rich, I don't know your thought on this, but I think if the court had come out the other way, it would have perhaps created quite a bit of turmoil and uncertainty over what was and wasn't covered by the machine gun ban.
Certainly that's true. And of course, one of the stark facts in this case was that for many years, ATF said that bump stocks were not machine guns. And so if they can shift gears so quickly like that, well, that suggests they could change their mind again in the future if they wanted to. And there are lots of different devices that people have been coming up with to make firearms shoot more effectively, which therefore in the minds of some people makes them more dangerous. And therefore, if you were to allow ATF to, on its own, write the law on this area, there are all sorts of other devices, and I won't go into all of them, that ATF could hold the same thing. And I thought that Justice Alito's concurring opinion was right on the mark, where he said that this is an issue that's totally up to Congress. If Congress decides, as a result of the experience with the shooting in Las Vegas, where a shooter used bump stock equipped semi-automatic weapons to kill about 50 people in a short period of time, that these are too dangerous and we ought to get rid of them, that's for Congress to decide, just as it's for Congress to decide the legality of all of the other potential devices that ATF has been threatening to ban.
John, the dissent said that this decision puts machine guns back in the hands of civilians. Is that an overstatement?
Well, I think it begs the question, right, whether these devices are machine guns. I think it's also based on kind of a misunderstanding of how effective these things actually are. I think there's no question that a bump stock equipped firearm, if you're used to using it, can fire a lot of rounds quickly. In most situations, I don't know that makes it more dangerous, because it becomes much less accurate as you're doing that, is my understanding. And then, third, if it does become a problem, as we were just talking about, and as Justice Alito said, there's a readily available and, in fact, the constitutionally prescribed solution for that problem, which is legislation, which in this instance I don't think is unrealistic. I think it's very easy to imagine that you could see bipartisan support for a law addressing these things if they do become an issue. In a lot of areas that...
As long as it really only went after bump stocks.
That's right, yeah. But that's part of the political process, right, is finding a narrower version or a compromise that there's buy-in from multiple different groups on. I think there is, in a lot of areas, it's not realistic, right, to say, well, Congress can just fix it. And that's a real problem, and that, is a problem that has deranged our legal system, I think, because courts are feeling the pressure to step in and fill that void. I think the derangement kind of then runs in both directions, because Congress is happy to not do its job if someone else is willing to do it. So that I think that is a real broader issue, but here I think, again, it is easy to see that there could be a congressional solution if one is needed.
Yeah, in fact, at earlier stages of the litigation, Rich, folks kept saying the same thing, that, well, Congress could never come together and pass legislation. And then in the middle of the litigation, Congress came together and passed a bipartisan gun control bill. I think it was in June of 2022, if I remember correctly. but they didn't include a bump stock ban in that. That was right after the Uvalde shooting in Texas that John Cornyn led that effort.
Right. There certainly are plenty of gun control laws that have been adopted over the last 30 or 40 years, so there's no reason to think that there couldn't be another one. I think the feeling of gun control advocates is we don't want to waste our efforts on this law, because if we can win it in the courts, then we can have our gun control law cover another subject, and there are only so many we can pass in a year. But as John said, this is really just the legislative process at work.
And I believe there are 15 states that ban bump stocks at the state level, so it's not as though states don't have, at least I'm not aware of any successful challenge to a bump stock ban at the state level on Second Amendment grounds, for example.
That's correct.
Okay. There seem to be a lot of misconceptions about I'll say the decision, but really maybe the implications of the decision. And John, one of them that people talk about, you alluded to the rate of fire, which I think is, I've heard numbers between 400 and 800 rounds a minute, which at the upper end of that is getting pretty close to the rate of machine gun fire. But a lot of the news media that is reporting on this doesn't point out the size of the magazines for these semi-automatic guns that are equipped with a bump stock, which is not 400 to 800 rounds. It's like maybe 20 or 30 is a pretty good sized magazine on one of these.
I think that's right. I think kind of the average, larger size magazine that comes standard on, for example, the AR-15 is like a 30 round magazine. So that's a theoretical rate of fire, but no one is in practice achieving that rate of fire, having to switch magazines out. And again, the military trains its soldiers not to use fully automatic fire in most situations because it's not as effective. It's very difficult to maintain control over the accuracy of the firearm.
They use 3-round bursts typically?
Yeah, correct. It's only kind of in specific military situations where you need to have suppressive fire on a position where they do use the fully automatic option.
And Rich, I think the president called these weapons of war, which I'm not aware of any branch of the military that hands out bump stocks.
That's correct, yes.
But there was a case in the Navy Marine Corps Court of Appeals where there was a soldier on a base who had a bump stock and was arrested. And what happened in that case?
Well, in that case, he was convicted for illegal possession of a bump stock, and then on appeal, the Military Court of Appeals reversed the conviction on the grounds that bump stocks were not, in fact, machine guns and therefore weren't illegal. And at that point, the government had the option of appealing further. It chose not to. The result was that at that point, it was totally legal for soldiers to have bump stocks if they wanted to on their military bases. But once they stepped outside of it, they were in danger of being charged in civilian courts.
Although that might be true of real machine guns too. But I thought I did think it was telling that when the Navy Marine Corps Court of Appeals looked at this issue, they said, well, these aren't machine guns. If the military doesn't think it's a machine gun, it's not a machine gun. So I thought that was pretty telling. The other sort of source that has been ubiquitous throughout this litigation at the various levels is Senator Dianne Feinstein, who said from the very beginning that ATF could not ban bump stocks this way, that it would never survive a court challenge, and that Congress needed to be the one to ban it. And that's why she was supporting legislation back at the time that would have led to a bump stock ban from Congress. As soon as ATF issued this rule, all that legislation basically died down. And here we have Senator Feinstein featuring again at the Supreme Court level. John, were you surprised to see Senator Feinstein resurface here?
Well, I wasn't surprised that people took advantage of that and brought to light that quotation because coming as it did from Senator Feinstein, obviously it was pretty effective, and I think it is
a noted gun control advocate.
exactly. Not a friend on the merits to the parties challenging the ban. But I thought it is actually pretty interesting and enlightening, because usually what we see is, if Congress thinks it can outsource its job to an agency and get them to do kind of the politically unpopular work,
the dirty work.
It is happy to do that, and that is, I think, a principal reason why we see the growth of the administrative state. The founders thought that Congress would be kind of a jealous guardian of its own power. And I think, unfortunately, what we've seen recently is that it's all too happy to give that power away and let the administrative state take kind of the political heat for taking these actions that might be politically unpopular, so long as the people in Congress can continue to go on cable news and raise money and get reelected. So it is sort of remarkable to see someone from Congress actually saying, no, you don't. This is a policy goal that I share, but I don't think you have authority to do it. I think we in Congress are the ones who need to act if action is needed.
And Rich, I think Senator Schumer also had said back 5 years ago that this was something that probably needed to be done by Congress. So his response to this decision was a little more muted than it might otherwise have been, I think.
I think it's absolutely right. And the political dynamics in that era, I think, were pretty obvious, that Democrats, many of them in Congress, wanted a vote to overturn it because they realized that there would be a lot of Republicans who would be put in a difficult position. They would have the issue used against them if they voted against the ban, but they would have the issue used against them by their gun rights supporters if they supported the ban. And so it's not surprising that Schumer and Feinstein wanted Congress to take a vote at the time.
Right. It doesn't seem like this. When the Democrats controlled both houses of Congress and the White House, somehow they didn't do a ban. But yeah, they always want to do it when it's going to have some political advantage as well. It seems like. But look, they're entitled to that. Congress is the one that gets to make these decisions. And Rich, you said at the beginning that the Second Amendment wasn't at issue in this case. So it is a statutory interpretation issue, as you said. But do you think that it resonates outside of ATF at all, or do you think this is a more limited decision? Should bureaucrats and other agencies take any lessons from this decision?
I certainly hope they will. I'm somewhat pessimistic that one decision is going to change the way administrative agencies do their job. But I think this decision, plus what I hope is a favorable decision overturning the Chevron doctrine that we're looking forward to later this week, could well get agencies to start saying, no, it's not our job to try to expand our authority to the absolute maximum. Rather, our job is to try to administer the law as we think it's best interpreted.
John, what about that? Do you think that there will be sort of wider implications, if you will, for this decision?
I agree that the reliable case, the Chevron case, is more likely to have much broader implications. But I do think that this is part of a trend on the current court of being very skeptical of exercises of administrative power. And I think, I mentioned at the outset that I was pleased to see that the Chief Justice was in the majority. I think, one issue that unites kind of both wings of the conservative majority on the court is skepticism of administrative power and administrative agencies. And this case is one of kind of a growing...
You mean the more conservative wing and the more moderate conservative wing? And when you say that?
The three and the three, right.
Okay.
The three kind of people in the center.
I hope you're right about that.
Knock on wood.
No, wait, that's down here.
I think there is a lot of skepticism. I think that does unite all six conservatives. And I think that is kind of an enduring project of the current iteration of the Roberts Court is finding ways to to tighten down on the administrative state.
You know, to me, Rich, one of the things that was striking about this case was Congress quite deliberately did not give ATF the power to write legislative rules. Most federal agencies, or at least most of the major federal agencies, have the power to write legislative rules. The fact that Congress didn't give ATF that ability, and then they went through notice and comment, they did all these things that made this look a lot like a legislative rule. In fact, the DC Circuit had upheld this in part by according Chevron deference, and only legislative rules get Chevron deference. That issue didn't make it up to the Supreme Court, but I wonder if there will be any sort of echoes of that issue, at least for ATF in the future, that they sort of have learned their lesson. You don't get to write legislative rules. Congress quite deliberately didn't want to entrust that power to ATF.
Well, I think ATF is perhaps unique among federal agencies in that most of its regulations are very much criminal law in nature, and that to the extent that you want to say that an agency ought to have legislative authority, it's usually to write more non-criminal regulations. There's a real serious issue about whether what an agency says about criminal law should ever be entitled to deference. That's an issue that has not been fully decided, but long before there were attacks on Chevron, there were many people who argued that there should never be any deference to a federal agency that in effect creates a criminal law. And I think that the reason that ATF backed off of its original claims that deference ought to be afforded to its interpretation is because it realized that this particular regulation, 99.9% of its applications were criminal in nature. And so there's probably a lot less reason to be deferring to what they had to say.
But the court didn't say in this case no Chevron deference to criminal law interpretations.
And the reason they didn't was because the government didn't raise the Chevron argument. I mean, the Chevron is, for years, has been kind of on tenterhooks because the Supreme Court has never invoked Chevron to uphold a regulation in about 7 or 8 years. So if they want to defend Chevron in any context, I think the government was wise to try to limit it to civil context.
Yeah, John, your partner Chuck Cooper co-authored the cert petition with Rich on the Aposhian case, which tried to tee up this Chevron issue in the criminal context. The court rescheduled it, I think, 21 or 22 times, and then denied cert right after the oral argument in the front of the Fifth Circuit en banc in this case. So that maybe that issue will be moot if the court overturns Chevron entirely.
That's my hope. But yeah, Chuck has been fighting Chevron, I think, since certainly much longer than it's been popular to fight Chevron on the right side of the spectrum. It's easy to forget that it was Justice Scalia who was its greatest champion. I think a position he came to regret at the end of his life. But we've been trying to get Chevron.
Gene Scalia had an op-ed in the Wall Street Journal back in January, right around the time of the oral argument, that I thought was helpful in suggesting that Justice Scalia's opinion might have changed on that.
Yeah, and we've been trying to get that decision up for years and years. So very happy to see that it finally made it up, and again hopeful that the court comes down the right way on that. But as Rich mentioned, as a practical matter at the Supreme Court level, Chevron has been, if not dead, zombified for 7 or 8 years. The government flees from Chevron. If anybody brings up Chevron at a Supreme Court oral argument, it's the challenger usually who's trying to impute some reliance on Chevron to the government. But it still has,
The government brings it up all the time in district court and the Court of Appeals, and then when they get to the Supreme Court, they pretend like they've never heard of the word before.
It still has a great and pernicious effect in the lower courts, so hopefully the court will put a stop to that.
So what about other cases? So you had a case that was pending cert at the Supreme Court that the court held for the decision in
Geddes case, yeah.
in Garland v. Cargill. So what happens to that case now?
We're kind of still discussing what happens to it. Obviously,
Okay.
we're happy. However, whatever the judgment looks like below, but obviously it's the issue has been decided by this case in our favor. So.
Right. And Rich, the Aposhian case is still out there in the 10th Circuit.
And actually, we are more optimistic about getting good relief in the Aposhian case than we are in the Cargill case, because the Aposhian case now is going back in front of the district court and in front of a judge who initially ruled against us, but at least was thinking clearly about the issue and realized that it was a relatively close case. In the Cargill case, there is a district judge in Austin who, even after the Fifth Circuit ruled in our favor and said that the regulations should be struck down, he absolutely refused to grant us any relief. All he did was to sua sponte issue a one-sentence order that says judgment is issued for the plaintiff, Mr. Cargill, and when we filed a motion to ask him to amend the judgment, he denied that. And so we are up in front of the Fifth Circuit on that issue because there's a lot of potential relief that we want beyond just a piece of paper saying that we win on the meaning of the law. Among other things, Mr. Cargill has 2 bump stocks that he surrendered to ATF, and he wants those back. So he would like injunctive relief in that respect. Also, he was denied valuable property by the government for, I guess, the last 5 years now. And so he would like to recover damages for the temporary taking of his property for 5 years. And I suspect that the government will fight that relief, and therefore we would just as soon have that issue remain in the Fifth Circuit, where we think we can get a fair hearing, as opposed to having the case go back immediately to the district judge, who I strongly suspect will go out of his way to deny any relief that he can get away with denying.
You might say the Fifth Circuit is better than Ezra?
Yes.
What about the Sixth Circuit case? There's also a Sixth Circuit case floating out there. Does either one of you know what's happened with that one? I think there was an order from the Supreme Court yesterday.
It denied cert.
Denied cert.
Because that's the Hardin case from Tennessee. The plaintiffs won in that case in front of a divided panel of the Sixth Circuit. So presumably Mr. Hardin will be asking for some sort of relief from the district court now.
So one question that I get from people is, so now that the Supreme Court has ruled on this issue, what happens if I find the bump stock that I lost for 5 years? And I tend not to give legal advice on that topic, but if either one of you wants to weigh in on that, I'll give you the opportunity.
Well, based on today's or this week's decision, bump stocks have always been legal, and it was just an erroneous interpretation of the law. So therefore, the fact that some people may have hidden away their bump stock and did not comply with the ATF order, which said either destroy your bump stock or do as Mr. Cargill did and turn his bump stock into the government. The mere fact that you disobeyed an illegal order, my thought was that it wouldn't create any legal jeopardy, and therefore go right ahead, pull your bump stock out of the closet.
Run a big risk, but as it turned out, it might be okay now.
Yes.
Yeah. What about another issue that didn't really come up in the case was the rule of lenity, and this was a big part of the Fifth Circuit's en banc victory for you, Rich. But and if I remember correctly, we proposed a question to the court for a question presented on the rule of lenity. The government objected to that, or said, well, it's really already fairly encompassed by the government's question presented, and the court didn't expand the question presented, but didn't really reach the rule of lenity issue here.
Well, the rule of lenity is a rule that is somewhat in conflict with Chevron, because it says that when a criminal statute is ambiguous, that ambiguity ought to be resolved in favor of the criminal defendant in a case. In this particular case, the Supreme Court didn't reach the issue because both sides said the statute's not ambiguous. It unambiguously supports our side. The court presumably would have reached the issue if it thought that the statute was ambiguous. I think the trouble with getting an expansive ruling on the rule of lenity in this case is that there's real division among the conservative members of the court about how broad the rule of lenity ought to be. Justice Gorsuch thinks that basically if there's really any ambiguity, you ought to apply the rule of lenity. I think that several of the other justices, particularly Justice Kavanaugh and Justice Barrett, have the feeling that no, the rule of lenity is, as far as they're concerned, is a judge-made rule that doesn't necessarily try to interpret what Congress actually meant in this particular instance. So they would apply the rule of lenity only in those, what I think are pretty rare cases where the two interpretations of a statute are absolutely in equipoise and there's no way of deciding the case other than flipping a coin. Well, in those cases, they would allow the rule of lenity to apply. And if that's the proper interpretation of the rule of lenity, it doesn't really have a whole lot of application just because there aren't that many cases where there is absolutely no way to decide the issue.
Right. Do you want to say something about the rule of lenity, John? I can ask it as a question. So the Sweet Home, or Babbitt v. Sweet Home is still out there, the drive-by footnote
right.
that Justice Scalia used to talk about. Is that an issue that litigants are going to still care about after the Cargill case?
So I think, again, this conflict between lenity and Chevron may go away if Chevron goes away. I think there is ferment, like Rich said, I think there's ferment on the court over what the role of lenity is, with Gorsuch in particular, I think, being a champion for it playing a broader role. I don't know. I think there are principled reasons to be skeptical of lenity having a larger role. I think a lot of textualists like Justice Barrett are skeptical in general of the so-called substantive canons that kind of import basically judge-made policy preferences into the texture of statutory interpretation. I also think lenity in particular is in some tension with the venerable jurisprudential principle, bad man stays in jail, which for some conservative justices, I think is maybe, even if a subconscious, is a reason to not hope for a broader rule of lenity.
I think Chief Justice Rehnquist was a fan of that particular canon, if I remember correctly. Well, I'm going to throw it open to questions from the audience here in a minute, but I wanted to give each of you a chance. Rich, if there's anything else about the decision that jumped out at you, or something else that you wanted to say about the ramifications of the case.
Well, I'd like to talk a little bit about the background of the case, which is obviously there were two different issues in the case. One about what is a single function of the trigger, and the other one is what does automatically mean. And so we went through a lot of back and forth about which of those two issues to accentuate more, and ended up that we were both right because the court ruled in our favor on both of those issues. But on the issue of ambiguity, I wanted to give a shout out to the summer clerk program here at NCLA, because one of our summer clerks worked on the issue last summer, and there was the government always, when they were talking about ambiguity, when they talked about automatically, they were saying, well, even though human input is required to keep the weapon going, something can be automatic even though it relies a certain amount on human input. And so, for example, and this was the example they cited in every brief they ever wrote, there's the automatic sewing machine, which, yeah, you can automatically turn the switch that causes the needle to go up and down, but your clothes don't get automatically sewed unless you also maneuver the cloth around a little bit. And so that's an example of an automatic device that still requires human input. Well, we were always a little confused by that because we never saw any sewing machine company that said that their machines were automatic, but we kind of just tried to distinguish that example and as best we could. Well, then last summer, one of our law clerks was looking at this issue, and he said, oh, wait a second. In 1965, the Federal Trade Commission came out with a rule that said, no more advertising your products as automatic sewing machines. And the reason is that consumers will be misled. They will think that if you call it an automatic sewing machine, all you have to do is flip a switch and your clothes will be automatically sewed. And we think that's deceptive. So they absolutely banned that use of that phrase. So now we know that rule was later rescinded back about 1990 when the FTC got rid of all of its rules that were very industry specific. But we know now why there are no companies that advertise their products as automatic sewing machines. And so when the government in its merits brief argued about how this is just like the automatic sewing machine, we came back at them with this example that one of our summer clerks last summer came up with. So there are summer clerks from NCLA who are in attendance in our audience today, and if any of you come up with something similar this summer, more power to you, and thank you all.
But we'll definitely put it in the Supreme Court brief if you find a gem like that. The Slide Fire would have run the risk of the FTC coming after them if they had advertised this device as though it makes your gun shoot like a machine gun. That wouldn't have held water for the FTC. John, how about you? Any other aspects of the case that you wanted to delve into before we jump to questions?
No, I think we've pretty much covered. I think I see the case as fitting into the current court's approach to administrative law questions. That's very skeptical of agencies aggressively asserting power. It's very skeptical of agencies pulling this kind of about face like the ATF did here. And I think that's what accounts for kind of the unanimity among the conservative wing of the court.
Yes, no switcheroos, as our colleague Russ Ryan likes to say. Kara, you have a question?
So, one of the things that has troubled me from the beginning, I think that when I've explained this case to folks on the outside that aren't really steeped in admin law, is they get really disturbed by the idea that an agency overnight created, 500,000 felons, give or take, and all the attendant problems with that, right? Prison sentences, substantial penalties, voter disenfranchisement. Do you take the Alito concurrence to sort of start hinting at the bigger problem that agencies shouldn't be criminalizing behavior, or is that a question the court is left open for another day?
I don't think that the issue has been decided, but I think that this case goes a long way in advancing the notion that maybe, yes, agencies should not be creating criminal laws. And you bring out a point, Kara, that we perhaps didn't discuss, that this case did create a real problem for people like Mr. Cargill, because ATF was not saying we're adopting a legislative rule that prospectively prohibits bump stocks. Rather, we are interpreting a long-standing 1934 statute as criminalizing possession of bump stocks. With the result, that means that everybody who at that time possessed a bump stock really had committed a felony.
Even though there was a piece of paper that you got with the bump stock saying the ATF had certified and approved this for sale.
Right. And now what the ATF did to try to ameliorate that problem was to say, well, we're going to use our discretion not to prosecute anybody who turns in their bump stock by a date in March of 2019. But that really didn't solve the problem for people like Mr. Cargill, because he is a licensed gun dealer. And even though he could not have been convicted of a crime, it would not have been beyond my imagination to think that federal bureaucrats would come in and say, oh, you committed a felony as interpreted by the agency I work for, therefore you're going to lose your license to sell guns in the future.
You think that there's a chance that a future administration might try to take federal firearms licenses away from people based on this?
Well, thanks to the Supreme Court decision, they won't do it for this reason, but it would not surprise me that they come up with other reasons.
Yeah, the other thing I care about that is because this was a statute targeted at actual machine guns, the prison sentence was a 10-year prison sentence if you're found in possession of an illegal machine gun. And there's no ability for the ATF to modulate that. They can't, because they can't do legislative rules, they couldn't say, well, but for a bump stock, it's going to be 5 years or 2 years or whatever might make sense. None of the congressional bans on a bump stock were 10-year prison sentences for owning a bump stock. But when you're trying to sort of put a square peg in a round hole, this is what you wind up with. When you have criminal rulemaking by federal agencies, you wind up with penalty structures that aren't fitting the crime that they have created. And that's a real problem as well, and one that I think will eventually force the Supreme Court to say something more definitive and broadly about administrative agencies not criminalizing behavior. If the court had gone the other way on this, I think it would have been open season on federal agencies writing criminal laws. So I would tell people who are listening to this program, you may not like bump stocks. You may see a bump stock in action and think, boy, that looks like a machine gun to me. But if the Supreme Court had allowed ATF to ban this device, it would have been open season on federal agencies writing criminal laws for things that maybe you do care about. Like maybe you don't think that you should have your gas stove taken away without a vote of Congress or what have you.
Or as one of our clients found out, posting photos of themselves or others on Instagram riding snowmobiles, right?
Just
Which
to
is
take an
punishable by
example,
6 months in jail.
just a stray example. But Rich, at oral argument, the advocate for the government, I think it was Brian Fletcher, conceded that they were just relying on prosecutorial discretion to not just on the federal firearms license, but their case was that they could come after every prior owner of a bump stock as a felon at some point in the future. And the Supreme Court didn't seem to like that answer very much.
And what he pointed out was, well, by the time of the oral argument, several years had gone by, and arguably there would be statute of limitation defenses that people could raise. But again, that's the underlying position of the government, I think, was pretty indefensible on that point.
Yeah. John?
One other thing that struck me about this, besides all the diagrams, was that you couldn't do this in the old F-thirds. I was going to say F-seconds, but they also linked, and I'm wondering if you've seen this anywhere else, because it does strike me that you couldn't have this before. Thomas links to animations and other things, so that if you really think he's wrong, if you have looks like a duck problem, please go look at this. And you couldn't do that before. I found it kind of interesting because I don't remember another big case where they've done that.
I can't think of any either. I mean, we in our amicus brief, we did the same thing. We linked to animations and I think also a YouTube video of someone bump firing with their belt loop just to show
that you don't need a bump stock to do it.
You don't need a bump stock to do this.
Right.
So what? My Levi's are now machine guns. Like, it's pretty ridiculous. But yeah, I can't think of another. But I'm sure it won't be the last.
Do we have an online question, perhaps?
Yes, we do, and then we have one of our clerks has a question. The online question is about the impact of this decision on ATF's pistol brace reclassification and potentially other similar laws that criminalize the paraphernalia. Is this going to make the ATF think twice? Do they have to go back and change these things, or does this case only deal with bump stocks and basically we're going to have to do this for each extra piece of paraphernalia that they decide is illegal?
Well, you guys may know more about the cases, but there are cases in the pipeline on all these issues that we're probably waiting to see what the Supreme Court did in Cargill to a certain extent.
Yeah, when the pistol brace was among the devices that I had in mind when I earlier said that there were a number of devices that ATF has been making angry noises about. I guess the theory of ATF was that a pistol brace allows you to shoot your pistol more accurately than you might otherwise be allowed to, and that makes them more dangerous, and that's a reason to
Another duck.
yeah. But the reasoning of the court's opinion in this case would seem to apply equally to that, and that therefore I'm hopeful that the ATF will not go forward with a rule to ban them.
John.
Yeah, I know they've also recently promulgated a controversial rule on who counts as a gun dealer, revising some of the standards there. So I mean, I think
As an interpretation of the statute?
correct. Yeah, and I think this case obviously only controls directly bump stocks, and the question is, will they be chastened? And that's really hard to say, I think, because I mean, this is part of the problem of one of the underlying problems of the administrative state, right? I mean, these people are not elected. They're not really accountable to anybody. I suppose you could see in an election year them actually not caring that much that they've been. I mean, look at for example, President Biden on the student loan issue, right? I mean, it was very directly and clearly rebuked
A year
by the
ago
Supreme
this
Court.
week. Yeah.
And he's like, okay, I can't do it that way. How about this one? How about this one? He sees little political cost and maybe political benefit to, keep sticking his thumb into the eye of the court, which is a really troubling dynamic.
Yeah, absolutely. Fortunately, there were two federal district court decisions yesterday, one out of Kansas and one out of Missouri, that at least upheld partial preliminary injunctions against the student loan cases. Ivan?
Yeah, so my question is about whether the rule of lenity is consistent or inconsistent with the principles of textualism. So I've always understood Justice Scalia's criticism on purposivism about having issues with due process and notice, because the everyday citizen wouldn't be able to understand the legislative history or the congressional intent. I feel like the rule of lenity has the same principle. If even 9 Supreme Court justices couldn't agree on what a criminal statute means, how is the everyday citizen going to understand what is prohibited and what is not? So I'm curious of what your thoughts are on that.
Well, it sounds like you are in agreement with Justice Gorsuch. That's exactly his feeling, that if a person doesn't know that what he did was criminal, that it violates due process to impose criminal sanctions against him. I think that argument is a little bit weakened by the fact that we have hundreds of thousands of criminal statutes out there, and the fact is that most people have no idea what those criminal statutes are, and very few people actually read a statute and try to figure out exactly what it means, and so that would be the argument in favor of saying, look, if Congress really wants to decide an issue, it ought to write it in the statute, and it, to a certain extent, it can directly grant an agency discretion to interpret specific provisions in the law, but that if a law might be somewhat ambiguous, nonetheless, there's no reason for the courts not to do their best job of trying to figure out what it means.
Yeah, I think there's different ways to understand the rule of lenity, right? So one is kind of what you described. I mean, our legal system recognizes that there are cases of genuine ambiguity, and the way we handle that is we assign burdens of proof and burdens of persuasion, and if you can't meet your burden of persuasion to show me that this law applies, then the government's going to lose, right? I think understood that way, it's pretty uncontroversial that lenity should apply. If it can also be seen more robustly as requiring a higher degree of clarity from Congress, right? And I think this is how Justice Gorsuch wants to use it. And that whether that's consistent with textualism depends on your understanding of textualism, I think. But there's certainly a case that what that essentially does is imposes a clarity tax on Congress, right? You have to not only summon the political will and the votes to get through bicameralism and presentment in both houses to achieve the outcome you want, but you also have to do it with language that's extra clear. And sometimes less clear language is the price of the compromise that allows a bill to pass. And so there is a textualist argument that by kind of increasing the cost of legislation on Congress, courts, when they're imposing these substantive canons, are acting contrary to congressional intent in a way that textualism doesn't approve. So it's a tricky question.
I think we have time for one last quick question.
Yes, we have one more online question, and this is about the SEC, oddly enough. So the question is, if everything is true, what we said about the criminal laws, what about these draconian so-called civil rules that the SEC hands out that are so extreme that they feel and act in many ways worse than criminal laws? Certainly, in many instances, worse than say a misdemeanor that you could walk away from after after doing some community service. Your career, at least, is not ended, and you're not bankrupted and radioactive in your chosen profession. Is there any chance that any of this reasoning or this case helps or is applied to some of the stuff that the SEC does?
Because this is totally a statutory issue and not a constitutional issue, I'm not sure it would. But I recommend to you the writings of Professor Philip Hamburger, who is the founder of NCLA, who argues, I think, very forcefully and persuasively that when you have very large civil penalties, they are really the equivalent to criminal sanctions, and therefore similar rules ought to apply. And particularly when you have to recognize that in most cases people don't get incarceration terms, and certainly corporations can't be incarcerated, that to say that there is this huge distinction between the kind of sanctions that the SEC routinely imposes and what criminal courts imposes, I think that's a very artificial distinction.
Well, it's a big week here at NCLA. We are still awaiting two cases at the Supreme Court. So Garland v. Cargill was the first case of ours. We're still awaiting the outcome of the Relentless v. Department of Commerce case and the Murphy v. Missouri case. And as soon as we have decisions from the court in those cases, stay tuned. We'll have Lunch and Law episodes on one or both of those cases, and look forward to discussing that. But obviously, we were thrilled that the Supreme Court ruled in favor of Michael Cargill, our client, in the bump stock case, and was delighted to have the opportunity to discuss it further today. Would you please join me in thanking Rich Samp and John Ollendorf for their presentation here today?